AV, you ready to rock and roll? You good to go? Karen, you good to go? All right, good evening, folks. It's 6 o'clock. We're going to go ahead and call to order the November 20th, 2024 Planning and Zoning Board meeting. If you would join me in the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, and for record-keeping, that sounds awfully loud. For record-keeping purposes, we've got to my left, Brad Cohn, Patrick McTeague, Steve Gannon, and Marilyn Romano. And to my right, we've got Brian Donaldson and Sherry McCartney. Oh, and here comes Jay Scheckman. So Jay is here on time, won't get a demerit. All right. Would somebody like to do the approval of the minutes from the October meeting?
So moved.
Second.
Moved by Mr. Donaldson, seconded by Mr. McTeague. Any discussion? All in favor, say aye.
Aye.
Any opposed? Thank you. Next, anybody who plans to speak on any of the three items tonight, we will need to get you sworn in. So at this time, I ask anybody who is going to speak publicly to get sworn in.
Okay, please stand to be sworn. Okay. All right, do you swear or affirm that the evidence that you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Disclosures.
Okay, and then is it the board's pleasure to make the staff recommendations for each item part of the motion?
Yes.
So that is the staff report and recommendations?
Yes.
Okay.
Okay, we're going to start with case UDP Z24010. We'll start to my left. Brad, would you like to give some disclosures?
Spoke with applicant's attorney.
Ms. Romano.
None.
I spoke with applicant's attorney, Steve.
Communication with applicant's attorney.
Jay?
None.
None.
Site visit.
And I have no disclosures. Okay. Where'd Stephanie go? There she is. The floor is yours.
Good evening, members of the board. My name is Stephanie Toothaker. I'm here on behalf of the applicant, 6 on Powerline LLC. We are proposing a rezoning of, I think it's a little bit off while you fix it. It's property, it's an assemblage of 8 lots that is roughly at the corner of Sistrunk and Powerline. And I do want to make one notation. There is a clerical error in the staff report. The property size is 1.609 acres, which is 70,125 square feet. So just a quick correction on that. Are you able to center that? Yeah, no, it's like cut off. Well, I think you'll get the idea. It's a little cut off on the sides. There we go. That's better. So next slide. So these are the lots. I just want to point out that the lots that are immediately to the north have already been rezoned. So this is a continuation of the pattern of rezoning that is on this block and in this general location. So next slide. You can see that we have actually notified all property owners within 300 feet. We also did a number of public participation meetings, which I'll talk about in a minute. Next slide. It is in the northwest rack, so it is consistent with the underlying land use and the ultimate goals for this area of the city. So next slide. And this shows you the pattern of rezoning. So you can see that the property in purple is the zoning that we are going to. And of course, these properties are being requested to zone to that same zoning category. So from the RM25 to the Northwest RAC MUW. Next slide. We have done a full analysis of the rezoning criteria. We've worked with staff on that. I don't need to read this all to you. I would like to submit it for the record. It is compliant with the, as I said, not only with the pattern of rezoning, with the what's happening in the area generally speaking, and also with the underlying land use. So next slide. These are the list of all the meetings that we had. As I said, we did do a public participation meeting. We met with Progresso Village. We met with Historic Dorsey Riverbend. We met with Home Beautiful Park. And of course, tonight is the Planning and Zoning Board. We also held a virtual public participation meeting for anyone else that was interested in participating. And I think that's the end of my presentation. I'm happy to answer any questions.
Any questions for the applicant's counsel before we open it up to the public?
Yes, I do.
Go ahead, Marilyn.
On those public participation meetings, what were the result of those meetings?
So those boards don't issue, they did not issue letters of support, and they also did not say that they were opposed. They were, it's in the Historic Dorsey Riverbend, so these were all in person. We did one virtual, but the rest of them were all in
So
person.
there was no comment from those?
No comment.
Thank you.
Steve, you have a question?
Yeah, my question's regarding the parcels. It's you've got an irregularly shaped lot, and my question is the fact that you have one parcel on the east side zoning also. Are these all owned by the same people? Are you trying to get the whole block? Or you
We're
just
trying to get
go-
the whole block, yes.
You are trying, okay.
We
that-
are.
That was I was
So,
trying to figure out
so
curiosity
we
what you're
originally,
doing.
and in fact, one of the issues with why we had to change the square footage on the lot, we had originally thought we were going to be able to do them all at the same time. I will more than likely be coming back before you with the rest of the block, and we'll catch up, and so it'll be a full block assemblage.
Got it, okay, thanks.
Just
Anyone
another
else?
quickie? Can you go to the map further out that shows the underlying, where all of the NWRAC zones are? Because I want to see, eventually, the whole thing is going to be rezoned.
Yes, I'm assuming.
That is the theory, okay?
Right.
And the theory is that way because the underlying zoning was changed, or the comprehensive plan says that this should all be that zone.
Yes.
So how are we gonna keep doing this one piece at a time? This is a question for my colleagues here. Are we gonna keep doing this one piece at a time?
That issue's been brought up numerous times. I brought it up myself
Uh-huh.
a couple of decades ago. So I think the answer is yes.
Yes, okay, all right.
That's what we do.
I just
Keeps
looked at
us
it
in
and
a
I said,
job.
what do we wait,
Yeah.
Keeps us in a job.
We do I know in Uptown,
I-
the city takes a more aggressive
yeah.
approach, but,
Yes.
okay, just as inquiring.
Yes.
We
Anyone
could
else?
always make a communication to the city commission to recommend rezoning the whole area.
We could if we
Yeah.
wanted to, yeah.
All right, any other questions for the applicant's counsel before we open up to the public? Thank you, ma'am. Is there anyone wishing to speak on this item? Hearing and seeing none, we'll close the public participation, bring it back to the board for further discussion or a motion. Motion, Marilyn?
No, I wouldn't move it because I wanted to see the big picture, but I certainly will vote for it if somebody will move it.
Well, we're trying to make this a record night to get out of here, so
Okay.
somebody needs
All
to
right,
make a motion.
all right, I make a motion, then I don't have my cheat sheet.
That's why I didn't.
I don't have
that's why
my
I
cheat
didn't
sheet,
do it
that's
either.
why nobody wants to make the motion.
We're dependent.
Do we have a cheat sheet over there?
I need to get better control over this board, huh?
Let's see. Gosh, I usually bring it. I forgot. Do I have it online? I don't have it online anymore.
Do you see, we don't have
That's why
paper,
nobody
we
wanted
didn't
to
bring
make a
paper.
motion, just for the record.
Right,
That's 100%. We don't have our.
Everyone forgot.
Obviously, next month we'll have it as part of our electronic,
There you go. I'm gonna put it on.
I moved to approve.
well, that really bothered you, huh?
Conditions. Now they get all this jargon, man. I don't know. Perfect. Marilyn's gonna make a
It's a
motion.
rezoning, right?
Thank you.
All right, rezoning, thank you.
Marilyn.
Rezoning, sorry.
Here we go.
Okay, I make a motion to, I move to recommend the approval of case number UDP Z24010, based on the following findings of fact in the city staff report, and based on the testimony heard by the applicant, and the board hereby finds that the application meets the applicable criteria of the ULDR cited in the staff reports. And we adopted all of the conditions for all of them, so I don't have to repeat that, do I?
No.
No?
No.
Okay, that's my motion.
So before you second it, do we need to, have you guys memorialized what Ms. Toothaker was alluding to with the change in the square footage? Okay, all right, thank you.
I second the motion.
Got a motion, a second, any further discussion? Hearing none, Karen, if you call the vote, please?
Yes.
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 Thank you very much.
Have a good
Steve
evening.
Gannon.
Well, we'll see you on item number 3.
Steve Gannon, yes, as well.
All right.
No problem.
Next case, number UDP A24025, disclosures. Brad?
Spoke with applicant's attorney.
I spoke with the applicant's attorney.
Spoke with applicant's attorney.
I spoke with the applicant's attorney.
Spoke with applicant's attorney.
None.
Site visit.
And I spoke with the applicant's attorney, and I did a site visit as well.
Site visit as well.
Before you launch, Robert.
Yep.
Apparently there's an issue with the exhibit, one of the exhibits to this.
Yeah, good evening. We were having technical issues from your iPads in order to access all the backup material, but we're setting it up through IT. So when Robert's done with this presentation, we can pull up the exhibit, any exhibit that you need to see on the monitors in front of you.
Perfect, thank you.
All right, good evening to the chair, members of the board. Robert Lockery on behalf of the applicant. I'm joined tonight by one of the principals of the applicant, Charlie Ladd, along with Sarah Del Negre with Flynn Engineering, who is our planners and civil engineers. The request is before you tonight is an amendment to a site plan that was previously approved. It involves a couple changes. Specifically, we're reducing the number of hotel rooms from 140 hotel rooms down to 81 hotel rooms, adding 17 residential units to the project, increasing the height by 2 floors for those residential floors, and modifying the parking reduction to actually ask for less of a reduction. In other words, the deficit between what is required and what we've provided is less with this amendment if approved. The property is located at the northwest corner of 10th and Las Olas, southeast 10th Terrace, and just south of southeast 2nd Court. As I said, this project was previously approved for a hotel. It went through this board, went to the City Commission, and actually was reviewed again by the City Commission in 2022. So this is an amendment to that approved plan. This is an overview of really the location, which is on the left side of this side. It's, as I said, at the northwest corner of 10th Terrace and Las Olas. What you see there is the ground floor of the hotel, which includes an alley which comes through at that ground floor level with access to the properties to the west. Also for the drop-off for the hotel, which comes off 2nd Court from the north, circulates through a porte-cochere underneath the hotel, and then exits out onto 10th Terrace. One of the reasons we show this as part of this project, the majority of the parking for the building itself is actually subterranean parking. It's underground, but there is a portion of overflow parking that's located at this corner, at the top right corner, which is to the east and north side of the site, which is a surface parking lot. We'll get to some of the modifications that are being made to the street itself and improvements that are being made as part of this plan and with the improvements to the parking lot. This is a view of the proposed hotel looking to the northwest. Here you see at the bottom left side, Las Olas Boulevard. What you see there is kind of the new pattern that new development along Las Olas has been including, which is a landscape strip with shade trees, in this case oak trees, then a wide sidewalk, in this case ground floor retail. Then coming around the corner as you kind of go around to the right, that is along 10th Terrace. Again, landscaped and shade trees up against the street, a wide sidewalk, and then what you can see here also is the entrance exit into the hotel. The 2nd floor of the hotel is pushed back from Las Olas. That's an outdoor terrace area, which is an amenity for the hotel. And then on the top floor, The amenity deck with the pool area is at that top portion on the south side, with the indoor amenity located on the north side. Those of you that saw this a couple years ago when it was presented, it'll look very familiar because it's really the same structure. The only thing that's changed, there's 2 additional floors, which are basically in the middle that bring the whole height up a little bit. The project does meet all your zoning requirements for the zoning district. It's within the maximum height, meets all setback requirements, landscaping, open space, et cetera. Whoops, wrong way. Just quick views of the inside. This is when you come in the ground floor. This is the reception area, which leads you with the stairwell up to the second floor, which is the main area of the hotel. This is that kind of central assembly area within the hotel, which will have nice seating. And it's an amenity not only for the hotel, but also for the residential units that'll be located here. And then quick to the last one, which is up on the roof. This is the cafe, which is the rooftop cafe, which then will look out and you can walk out into the pool patio area as well. Won't go through all the amenities, but just want you to see some of the fixtures that are within the proposed hotel. Again, this is the view looking to the northwest. This is a opposing view. In this case, you're looking to the southwest. At the bottom of the screen, you see 10th Terrace, and then on the right is Second Court. One of the things you see here is the building's actually set back further than it would be required to under the code, which results in a pedestrian plaza both on the southeast corner, but also on the northeast corner, which you see here, and you also see the entrance into the porte-cochere. Again, not only the improvements along 10th, but also a wider sidewalk and landscape improvements along 2nd as you head to the west. Whoops, wrong way again. As I mentioned earlier, the building is set back further than is required by code, and as a result of that, we can have bigger sidewalks. Along Las Olas Boulevard, the sidewalk varies from about 14 feet wide at its widest point down to about 9 feet at its narrowest pinch point. Along 10th, which is along the right side of the building, again on the left side of your screen, the minimum sidewalk width there is 10 feet. It actually expands up to 13 feet. And then along Southeast 2nd Court, you've got a 7-foot sidewalk at all times, but in some areas it actually does flare out. In addition to the improvements that are being made along the side of the hotel, the developer is also committed as part of this package is making improvements on the east side of Southeast 10th Terrace, which actually cuts up, curves around 2nd Court, as well as improvements to the intersection of Southeast 2nd Court and 10th. One of the things that hasn't changed from this building is the way it's perceived and seen on the street. The basic design of the building, the uses of the buildings have not been changed. So here's a view along Las Olas. You see Ann's Florist on the left. Warby Parker is not quite seen there, but it would now be located on the right side. But you see the ground floor retail with the shade trees and the second floor terrace, which is pushed back from that frontage. This is along 2nd, so this is actually kind of the back of the building, which you see is still very attractive with a water feature, landscaping, wide sidewalks, and some seating areas. You see the improvements that are being made even beyond this project further to the east. And then this is a view looking south on 10th, where you see the improvements that are being made with the surface parking lot on the left, as well as on the right. And this is essentially mirrored on both sides of the street, both with the landscape as well as the lighting and the sidewalk. In addition to these improvements, the developer has also been working with the city to make improvements to the area of Southeast 10th that are north of Southeast 2nd Court. Many of you may know that area. It used to be a 2-way street. The city narrowed it to 1-way, but it's actually like kind of double wide 1-way right now with just some painting stripes on that. So one of the things that we're working on is to actually make this improvement, which is a landscape improvement, right-of-way improvement, whatever you want to classify it. I know we can't call it a park, but it's an additional green area where you don't need cards anyway to provide some relief. That is an overview. I will say that we have read the staff report. We agree with all its recommendations. We agree with the conditions of approvals they're suggesting. The project was presented many times throughout its kind of changes over the years to the Neighborhood Association. Most recently in June, we did have our public participation meeting, and I'd be happy to answer any questions you may have.
Okay, thank you. Any questions for the applicant's counsel before we open up to the public? I see a couple lights on. See a light off. See 2 lights off.
I have a question.
Go ahead.
For the additional parking that is acquired as part of this for the surface lot, how do we know that that's going to be there 5 years from now and that that's not part of another development and now we then have a parking short?
It's a great question. So there's actually two components to it. One is a parking reduction. And as I said, if this is approved, the amount of parking spaces that the project is deficient actually goes down. So it actually gets better. But in addition to that, the spaces that we use in that lot that are assigned to this facility, the city requires an off-site parking agreement, which requires that both property owners and the city sign that agreement. That gets recorded, runs with the land, and it can't be released unless other parking is made available. Yep.
Did you have a question, Jay?
No, I just playing with my light.
Okay.
Thank you.
All right, if there's no other questions, let's go ahead and open this up to the public. Is there anybody here that wishes to speak on this item? Hearing, seeing none, we'll close the public participation, bring it back to the board for further discussion and a motion or a motion.
Comment from me. We appreciate the streetscapes, going across the street and handling things and around in the area. I also want to make note that I think these are the first condos on Las Olas, east of Federal Highway. I don't know if I'm correct, but I think these will be the first. So we're starting condos on there. I'm happy that if we're doing that, we're doing high-end luxury, hotel-type luxury, and very, they should be better than just the downtown ones, was what I'm getting at. That's our special street, Las Olas. So I'm happy you're doing it right on that way. We'll see how this goes. Thanks.
Patrick?
No, sorry, I was.
Does anybody else have comment? Marilyn, have a motion?
I do. You ready?
Yes, ma'am.
Ready.
Okay, I move to recommend approval of case number UDPA 24025, based on the findings of fact and the city staff report, and based on the testimony presented by the applicant. The board hereby finds that the application meets the applicable criteria of the ULDR cited in the staff report, and we've adopted all of the conditions and recommendations of the staff report.
Who seconded it? I'm sorry. Brad, okay. Thank you, Brad. Any further discussion before we take the roll? Karen, if you'll take the vote, please.
Ms. Romano?
Yes.
Mr. Cohen?
Yes.
Mr. Scheckman?
Yes.
Mr. Donaldson?
Yes.
Mr. McKee?
Yes.
Mr. Carter?
Yes.
Ms. McCartney? Okay. Mr. Gannon?
Yes.
And Chair Rowland?
Yes. Congratulations. Okay, moving right along. Next case, UDP Z24012. Again, we'll start with disclosures. Brad, if you'll kick it off, please.
Spoke with applicant's attorney.
No disclosures.
Let me get this. I gotta check it out.
Steve?
I know I'm looking to see. Cypress King.
Stephanie again.
Yeah, no communication on this particular case.
Patrick?
I had a communication with the applicant's attorney.
None.
Sherry?
Site visit?
And none from me. Okay. Tyler?
Good evening, board members. Michael Ferreira, urban planner, case planner for item Z24012. This item, the subject property for this item is within the city's Uptown project area, which is part of the Uptown Master Plan and associated ULDR amendments that were adopted on November 5th, 2019. The ULDR amendments established the new zoning districts in order to implement the Uptown Master Plan. During the adoption of the ordinance, the City Commission requested that staff examine potential incentives that would encourage property owners to rezone their properties to the applicable new zoning districts. As an incentive, it was determined that staff would be able to process the rezoning request for property owners with their written consent. So this rezoning that you have here in front of you is one of those properties in that Uptown area that has provided that written consent to rezone their property. The request is to rezone 133,678 square feet, approximately 3.06 acres of land located at 200 West Cypress Creek Road from intense manufacturing and industrial M3 Broward County Code district to the Uptown Urban Village Southeast UUV Southeast SE district to permit the development of a private club facility. I'm here if you guys have any questions, and the applicant is here as well.
Okay.
Question?
Go ahead, Marilyn.
On the zoning map that shows the zoning categories, Where is the adjacent zone to which it is being zoned, or is it isolated? Is it attached to an existing rezone?
I'm sorry, I don't understand the question.
Can you bring up the map that shows, the colored map that shows the zoning? The zoning map.
For the Exhibit 1, the
there.
location map?
Uptown
The
Urban
overlay
Village. I'm
district
sorry,
Yeah.
now you see these,
I see the Uptown Urban
all
Village
different.
northeast, okay? You said it was going to Uptown Urban Village southeast?
Correct.
Southeast, that's not northeast.
no, what I'm, okay.
Yeah, so I'm trying to find where an adjacent zone, UVV southeast is.
There isn't at the moment.
So this would be the first one in a C of other districts. I'm just
Yes.
trying to understand.
Yeah,
I'm not-
yeah,
I'm
that
not
would be the
making-
first one that's there, yeah.
Okay. All right. Now, across the street is B2. That's not UVVSE.
No, I know that.
Okay. Yeah, no, I understand. I just wanted to understand the map. And so this is an isolated piece of that zone in the midst of other zones.
Correct, it's
Okay.
just this separate
I
parcel
understand.
that, yeah, it's trying to.
I understand.
But the district is already created, right? This is just the first property that's going into the southeast district that is already there, that this is part of the map of.
Correct, yeah, there's
Yeah.
already, the zoning districts for the uptown areas have already been created. We're just providing the incentive of moving forward and presenting the rezoning for the applicant.
Got it. And we will see a site plan eventually.
Eventually, yeah.
Okay.
Steve, you have a question?
Yeah. So this is looking at that zoning, the map and the parcel location. It's ideally located at Cypress Creek and Andrews Avenue. You're just over across Andrews a little ways is the park and ride. If people were, if residences were there and they wanted to walk to a park and ride, just south of there is the tri-rail. It's very good for getting around. That said, I kind of thought we were trying to encourage residents to move in that uptown urban village and get it mixed use and residents. And here we have a huge parcel that's going to be, I guess, is it going to be a big building, single building of a private club? And if so, is it going to be will it be a swingers club or something? What are the intents? What is the draw? It makes it a destination now, not where people live. I thought we were trying to make it a live, work, or live so-and-so. Can you reveal that? I know you don't have to.
It's
Live,
fine.
work,
No,
and
I'm happy
swing.
to.
Go ahead, you know.
Stephanie Toothaker on behalf of the applicant. A couple things. Number one, this property retains the county zoning, so the zoning has to be changed to come into the city of Fort Lauderdale zoning. And this zoning category is consistent with the uptown. This is an existing building, so we're not taking that building down. It's an existing office building. The idea and the proposed use is I don't know how else to describe it. It's a private club for a condominiumized private club for man caves for your automobiles. It's for your automobiles and your motorcycles, and the building is proposed to be retrofitted to accommodate what is becoming a very popular use, especially in areas like Southeast Florida that flood. So people that have expensive automobiles and motorcycles and things like that, they buy what is essentially a condo in the building, and they have car elevators that bring that up. And in working with the city's zoning director and the planning staff, it was best to describe that as a club use. It's not really a club. It's more a very high-end storage for automobiles and things of that sort.
Is very high-end storage permitted in the zone?
Yes, it is.
There you go.
Yes.
And it fits as a private
Why
club.
not call it what it is?
Okay. I've got a friend who had his 65 Corvette flooded.
Exactly.
In a warehouse bay in a storage place, one
Could
of
you give me
those.
his telephone
Yeah.
number? We'll reach out to
Yeah.
him.
He'd be interested, Will. I think he'll be very interested. There you
Chair, there is one thing that I have to disclose, but I don't think it matters because it's just a rezoning issue. But when it comes to Cypress Creek, a family member of mine owns Kimco Realty, which owns Regal Cypress Creek Station, but this isn't going to affect, I don't believe this is going to affect, but I do need to make that disclosure.
So noted, thank you. Any other comments, questions of the applicant's counsel? At this time, we'll open it up to the public for anybody wishing to be heard on this item. Hearing and seeing none, we'll close the public participation, bring it back for additional discussion or a motion. Marilyn?
So this is a rezoning, right? Okay. I move to recommend approval of case number UDP Z24012 based on the findings of fact and the testimony heard today, and the board hereby finds that the application meets the applicable criteria of the ULDR cited in the staff report. We adopt all of the conditions and recommendations in the staff report.
Second.
All right, we have a motion and a second. Any further discussion before we take it to a vote? Karen, if you'll call the vote, please.
Yes, Ms. Mamana?
Yes?
Mr. Cohen?
Yes.
Mr. Shepley?
Yes.
Mr. Donaldson?
Yes.
Mr. McTeague?
Yes.
Ms. McCarthy?
Yes.
Mr. Gannon?
Yes.
And Chair Wayman?
Yes. Motion passes. Congratulations. Thank you. All right. Next up, last case, UDP L24001. Lorraine, are you presenting?
Taking the long route.
Hi, Lorraine Tappan, Urban Design and Planning. To start, I wanted to hand out.
Can you turn your microphone on, please, Lorraine? Thank you.
Okay, great. Lorraine Tappan, Urban Design and Planning. Before I start the presentation, I wanted to hand out some corrections to the staff report. This is an amendment to the comprehensive plan's future land use element, specifically an amendment to the Parks, Recreation, and Open Space future land use designation. The purpose is to allow community facilities and utilities as a permitted use in this designation, with the requirement that community facilities and utilities not exceed 5 acres total in one park, or 5% of the total park area, whichever is less. The amendment was initiated once the fire department suggested rehabilitating, reconstructing the fire station at Birch State Park. Once Urban Design and Planning was alerted of this proposal, we reviewed the code, we reviewed the comprehensive plan, and we found that a fire station such as the one that currently exists is actually not listed as a permitted use under the Parks, Rec, and Open Space designation. So that also, after that, we also learned from Public Works that there may be some stormwater pump stations proposed in some parks. Currently, none of those parks have the parks future land use designation, but in order to allow flexibility in the future, we suggest including utilities as well as a permitted use. The text amendment language includes amending the ULDR to include criteria for future community facilities or utilities and parks. Criteria could include an analysis of alternative sites, design elements, neighborhood compatibility, and staff would recommend in those ULDR amendments that the Planning and Zoning Board would approve those uses to make sure that these uses meet the requirements and allows for a public process. I have a couple corrections to the staff report that I've handed out to you. And in Table 1, there's an update to the total acreage of community facilities that currently exist in Holiday Park to 4.19. The total percentage of that park area is 4.7%. And there's a change in the last sentence under comprehensive plan consistency. And the sentence should read, limiting community facilities and utilities to 5 acres or 5% of the total park area, whichever is less, and the Parks, Recreation, and Open Space designation maintains Parks, Recreation, and Open Space element objective PR 1.1, which ensures that parks, facilities, and programs adequately meet or exceeds the needs of the city's residents. That concludes my presentation, and I'm here for any questions.
Marilyn, I see you got your light on.
Yeah, why the change in the language? The language that we saw originally was 5% on the parks, whichever is less, and sufficient and functional open space serving the area residents will be retained, is now going to be changed to objective PR 1.1, which ensures that parks, facilities, and programs adequately meet or exceed the needs of the city's residents. Why the change?
The change you're referring to, so the proposed text amendment is that the limit of communities, facilities, and utilities would be a total of 5 acres or 5%.
That's the same. That's the same in the one that we have and the one that you just handed us.
Yes.
The language that succeeds that follows that, has changed. Why did you feel the need to change the language?
In the staff report?
In this, the one that you just handed us.
Yes, because the original language was based upon a version that was considered previously. And after further analysis, we decided that 5 acres or 5%, whichever is less, would be the best suggestion and proposal for amending this.
Okay. I know the 5% and the 5 acres. But the language is different. And I don't mean to be, and I'm not going to beat this one, but, it's similar language. I just didn't understand why you decided to change it. Other than that, is it's got to meet an objective? Is it better to meet an objective than it is to just state it? Is that what your thinking was?
If I may, I believe the correction that Lorraine handed out is language that's not in the staff report. The 5% is missing. But the text amendment language itself that would be adopted is in the exhibit has not changed.
I see on my little laptop here, the 5 acres and 5% is in the staff report.
No, the comp plan consistency section,
Yeah,
if you go to that section
comp plan consistency section.
of the staff report, so if you go down there, the correction that Lorraine made is at the end of that paragraph, it doesn't reference the 5%, 5 acres. So she wanted to clarify that in that
So now
paragraph.
we're saying it twice.
Yes, and then,
Okay,
but
fine,
what gets
fine,
adopted,
fine, fine.
what gets adopted, what gets adopted is the text.
So basically,
saying
it's
it twice.
maybe
Cool.
I didn't understand. It's basically a replacement of that last sentence on that section under comprehensive plan
As
consistency.
long as I understand, that's a good, twice is better than once.
worded in another section differently.
Okay,
But in the exhibit of the text amendment is the language that you were referencing, that
it.
remains, yes.
Okay, Jay?
Does it already provision that I guess, so if a facility is proposed, it's already written that it would go to the Planning and Zoning Board for review?
Currently, under the park zoning designation, utilities are required to be permitted as a conditional use. However, right now, community facilities there's no specific requirements for community facilities and parks. So we would recommend as a next step that we amend the ULDR to add criteria, including permitting community facilities and utilities both as a conditional use.
Okay.
Chair, if I may, in terms of the attorney, Dwayne Spence, just for context, the board is acting as a local planning agency in this function and reviewing this proposed change to the Unified Land Development Regulations to determine, well, not to the Unified Land Development Regulations, but to the comprehensive plan. Part of your task in this review would also be finding consistency with the Broward County Land Use Plan, and I want to read that language into the record. In the Broward County's Parks, Recreation, and Open Space permitted use category, it provides in Section 8 that community facilities and utility uses subject to the following are permitted. A use is intended to serve a public purpose for promoting health, safety, and welfare. B, the city can demonstrate that, I'm sorry, I'm reading from the wrong document. The Broward County Land Use Plan, Section 7 of the recreation and open space use states as follows: community facilities and utilities up to 5 acres, provided that community facilities and/or utility uses are publicly owned and intended to serve a public purpose to promote health, safety, and welfare. B, that the local government can demonstrate that it will continue to meet the minimum open space requirement of 3 acres per 1,000 existing and projected permanent residents. And C, that the proposed community facilities or utility use is limited to no more than 5 acres, and the municipality must demonstrate that sufficient and functional open space serving the area residents will be retained. So that language, our proposed language has to be consistent with that language. And once that language is adopted, as Lorraine has indicated, the next step to address your question is the amendment of the Unified Land Development Regulations to implement this. So the comprehensive plan provides permissive language, then the Unified Land Development Regulations would have to be amended to actually implement the language.
So how has this been working before? Like when you've wanted to add a community facility, like has there not been a process or an ability to do that prior to today?
No, we haven't had the process. Community facilities, some community facilities have been already permitted by the the Parks Zoning District, but in some cases, the parks, when it has a parks land use, I'm going to go back to a specific project that's coming up. In Riverland Park, there's a proposed stormwater pump. That has a Parks, Recreation, and Open Space zoning designation. However, it does not have a Parks and Recreation land use designation. So if we amend the ULDR, once that project is ready, we will require that project to come to the Planning and Zoning Board for conditional approval.
And if we do not amend the ULDR, what's the process to get that approved still? There has to have been some process in place.
For that utility, there's still, the code does require that it goes to the Planning and Zoning Board, but we're hoping to add more criteria for the Planning and Zoning Board's review, such as neighborhood compatibility, design elements, to make sure that in that case, if it's a pump station, that is properly screened and that it fits in with the park in the neighborhood.
May I jump in for a second, the Chair? The process is a public purpose use, which is a site plan level 4, goes to you all and also to City Commission. There are some being proposed in the neighborhood here. That'll be storm pumps in residential. It's not the same, but that's the process that you have to go through to allow those.
Right. Okay, so the process is the same as it was if we amend this. So I guess like the concern that I'm just trying to sniff out is like if all of a sudden, right, everybody's very sensitive about park space being taken, right? And I mean, there have been, not bringing up the pickleball courts, but the pickleball courts, for example, at Snyder Park.
You just brought them up.
Oh, like that never came to our board, and that's, I don't know, more than 5 acres or 5%. So I'm not sure. It seems like there's other ways for these things to happen anyway. I just am trying to think through if there's any way that this opens up, like we're talking about pump stations, but 5 acres is a lot of space, we have limited park space, so I'm just trying to think through if there's any way that this results in just more park space being taken away.
So this is kind of twofold in some ways. We're trying to correct some situations, like for instance, at Birch Park, there's the fire station that's there that's going to be rebuilt. That now kind of brought this to light because it has a park and open space land use. And having a community facility like a fire station presented issues under that land use. So we're trying to correct that. So that's one aspect of it. The other is we're getting from Public Works Department the increased need for stormwater pumps stations throughout the entire city. The ones in this neighborhood are residential, but there are some coming into park space, park zoned, and also park land use, which presents the issue for us. So we're trying to allow for that to happen in two ways, to fix the past and to plan for the future. Part of the future includes what Lorraine was saying, is having amendments to our ULDR that has criteria that establishes how we move forward. So Public Works then has to cite the pump station accordingly. We don't have any of those criteria right now if they go into a park zone. in that sense, and review and add it as a conditional use and so forth.
So how did they build the pump station in Peter Feldman Park?
The land use is not park. The land
Peter
use,
Feldman is not zone
it's zone
park?
park. It's zone park. It's not
Yeah.
land use park. It's land use regional activity center.
Oh, this brings up an interesting question. All of these parks that we've been rezoning for the zoning, do they all have a similar situation where they're not designated as land use park?
So what gets interesting about regional activity centers or RAC, you can have those uses there. If it's residential and trying to rezone to park, you can, because that's permitted, but the land use could remain residential. We're trying to clean all that up. Some issues, I think you may recall, there was the Beach Community Center not long ago on the agenda. We had to pull it because the land use is commercial. Under commercial, it did not allow for parks to rezone the parks, so we had to pause that. So it depends on the scenario. For the most part, all the rezonings you've seen have complied with the land use plan because we wouldn't have been able to process it. Whether it was actually park land use, it depends on the site location. Some of them do have it, some of them don't.
Okay,
that's how-
I understand. It's an inconsistency, and, my next question is, the fire station, wouldn't that qualify as a community facility promoting the public health, safety, and welfare?
Yes.
So why are we doing this for them?
So that's the county's land use. We don't have that language in our comp
So we
plan.
have to have that in?
Exactly.
Ah, okay,
That's why.
okay.
Jay?
Did somebody point out a great concern that the fire station wasn't compatible with the land use? I find that hard to believe. And what is the largest a pump station could be?
5 acres.
How big are they? What's the biggest one?
They can be 4 acres.
5 acres.
No, generally the
5
pump
acres.
No, like an
stations
actual pump
are
station.
.03 acres.
So I
Yeah,
just don't understand.
About 1,500 square feet.
I guess I'm just failing to understand. It just seems odd to me that we're coming in with this 5 acre under the premise of pump stations, which are .02 acres. Just the whole thing seems very odd.
5 acres, we don't have a 100-acre park anywhere. So our largest park is 84, so it's a max of 5%. So the 5 acres is because we are matching up to the county of their terminology, but I'm not aware of a 100-acre park in the city, so we'd never have a 5 acre.
Holiday Park?
Is 84.
84.
So it's capped at
It'd be a
5%.
4 acre facility.
So
No, but-
I think the acreage we shouldn't be as concerned about. It's
Yeah, we
it's
usually
the
put an acreage or a
percentage.
percentage in there to have whichever is less, so we can apply either one depending on the scenario. But you are correct, most likely the 5% is going to limit what goes into these parks, because that's going to be the more restrictive aspect of it.
That would certainly work at Peter Feldman. It's certainly not 5%. Yeah. Okay.
All right, any other questions for Lorraine before we open it up to the public? Sir, are you here to speak on this item? I'm seeing that there's nobody else here, but I'll go through the motions. Is there anybody here that'd like to be heard on this? Bert, you want to say something? Okay, well, let's go ahead and close the public participation, bring it back to the board for more discussion or a vote.
I I move to recommend approval of case number UDP L24001. The board hereby finds that it's not a text amendment. The board
It is-
hereby finds that,
It is
oh,
a-
it is a
it
text.
is a
the
text
of
amendment.
comprehensive plan.
Yes.
The board hereby finds that the text amendment to the ULDR,
No, to the comprehensive
that's
plan.
right, that's not ULDR. Amendments to the comprehensive plan. Amendments to the comprehensive plan. Okay, that's all it is. I move to recommend approval of that case number, and the board hereby finds that the text amendments are consistent with the comprehensive plan.
Okay, we have a motion. Do we have a second?
Second.
Any further discussion before we call the vote? Steve?
No, I'm just.
Just getting ready for the vote? All right. Karen, if you call the vote, please.
Yes?
Yes.
Brad Cohen,
Yes.
Jay Sheckman,
No.
no. Ron Donaldson,
Yes.
Sharon McCarthy,
Yes.
Steve Gannon,
Yes.
and Chair Wayman.
No. All right. Next up is communication to the city commission. Anybody want to wish them a Merry Christmas or a Happy Thanksgiving? I think we should, as a board, send them that. Anything else that we want to tell them?
Rezone a whole area.
Huh?
Do we want to ask them to rezone an entire part of the city?
We
No,
have-
I think that's been discussed before. All right, so for the good of the city of Fort Lauderdale,
I have an item.
okay, is that for the good of the city, or were you,
It's for the good of us.
okay? That's the next item.
Okay. Oh, the good of us
So
is the
nothing
next
for the
item?
good of us. So does anybody have anything for the good of us?
Me.
Go ahead, Marilyn.
Okay, and I swear to God, this will be short. I know everybody is anxious, all right? Yeah.
We were on record
Okay.
pace. We were.
Yes, and so I would like to have a brief, very brief discussion about the code of conduct that was recently passed, and we've all, I assume, signed up for. And it's really very quick questions. In the adoption of this code of conduct, it says that, we shall follow this code of conduct and that the city commission, through the adoption of the resolution, a majority vote may remove or cause any member who violates the code of conduct to be removed from that board. But then there's an exception when inconsistent with the city charter, general or special law. Can you give me an example of what the exceptions would be?
So that's a catch-all provision. It can be a number of things. One thing that does come to mind that's kind of relevant to this board is that there is a provision that talks about quasi-judicial matters
Right.
and the ability, or that you should, let's say, that members should avoid creating the appearance of impropriety by refraining from engaging the public in public and private discussions about specific agenda items.
Yeah.
And so that might lend to some confusion to you all when lobbyists or applicants come before you. Well, there is a section in the state statute, section 286.0115, that specifically provides that in a quasi-judicial proceeding of a local government land use matter, a person may not be precluded from communicating directly with a member of a decision-making body by application of an ex parte communication prohibition. So that would be something that says specifically that we couldn't adopt anything with regards to ex parte communication that can bar an individual from talking to board members about land use cases in a quasi-judicial matter. And so that would be something that would be covered by this exception.
Okay, gotcha. Second question, very quickly. Some of these provisions say that I will refrain from using profanity, yada, 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 and disparaging remarks. Who determines what's disparaging? Is there any criteria for what's disparaging?
So interesting. The commission asked the city attorney at the time the same question, and he gave kind of a Supreme Court kind of answer. You know it when you see it.
All right, we'll stick with that one.
Have you seen a Miami Commission meeting anywhere there? Have you ever heard of it?
Disparaging. How about New Zealand? I saw that clip too. Okay, one of the last questions is, all of these things apply to, all of these to the city commissioners, the city manager, the city attorneys, the city staff, and citizens. Okay? So my question is, if I am in Publix and I get into a discussion with somebody in Publix and there's disparaging remarks thrown around, can I be thank you, remove me, but can we be removed for having this apply to citizens? I don't mind applying it to you all and commissioners, but citizens is quite overly broad in my opinion. What do you think?
The language is written broadly.
But then the penalties are extreme. I don't think so. Well, I mean, if I get into a heated discussion with somebody and they claim I disparage them, now we're in front of the commission and we're going to have a trial as to what's disparaging.
Just be nice.
Yeah, no, that's my mother's thing on this, is be nice, okay? But I'm reading it and I'm saying to myself, there's a lot of open questions here, open questions about my right to free speech, too. But I'm sure you've heard this before, so I'm going to not continue with that. And my last question is, having to do with private discussions about specific agenda items, reframing from engaging in public and private discussions about specific agenda items. We all get telephone calls from the applicant. Why is that different? And please assure me that it's different before I continue with that.
All right. That happened to be the example I just mentioned to you. So the Florida
Because there's
statute.
another law that says I can have private discussions?
The Florida statute specifically says in quasi-judicial proceedings in a local government land use matter, a person may not be precluded from communicating directly with a member of the decision-making
Then
bodies.
that's the end of my questions. Thank you very much for the clarification.
You're welcome.
Okay, anything else? Somebody want to make a motion for adjourn?
We're out of here.
Do we have something else going on? Did I miss something?
You two up there.
They want to get going?
What is this, a floor show, or?
And pushing us out of here. Wow.
Grade definition amendment presentation.
Defer this item.
That wasn't properly filed. We'll hear it next month. I was wondering why you were here, Bert. I was like, you know.
I'm never here, so. So
All right.
there is
So the
a
show
presentation
continues.
of the grade amendments, yeah, under the good of the city. This is a, no, this, Bert,
No,
Bert,
he's
he's not
serious.
here for security reasons. He's here actually to present. Yeah.
All right, good evening, Board. Bert Ford, Zoning Chief, presenting to you today a request to update the grade definition in the ULDR. Carland was here in March with a much more complicated version than what we have today. We have a pretty simple one today. A little background. So the definition, I've got a couple of timelines. So we're going to talk about before October of 2021 when the code was changed to what it is right now. So and we're talking about uninhabitable accessory structures like fences, gazebos, and things like that. When used to measure non-habitable accessory structures, grade shall be the ground surface at the base of the accessory structure being measured. And this next section is the kicker. If a retaining wall elevates the non-habitable accessory structure, grade shall be the finished ground surface at the base of the retaining wall. So you've got a retaining wall, and sometimes they put a fence on top of it, or they'll just continue the fence all the way up. But the retaining wall, the functional retaining wall is at a certain height, and then it continues up. Zoning called that measuring from the lowest adjacent grade, which is the neighboring property on the other side of the retaining wall. And what that did is that created an issue when we really started to strictly enforce the FEMA base flood elevation requirements. So, and we've had a couple of changes in the maps where it's really elevated BFE, much higher than it was 6, 7, 8 years ago. So what that did is precipitated a lot of people coming to the Board of Adjustments for variance requests, because if a lot or a finished floor had to be, if the grade was 3 and it had to be, sometimes I've seen it up to 8, but it averages around 6 or 7, then they were bringing in fill and filling in the whole lot with fill, bringing the entire lot up, building a retaining wall all the way around the property and bringing the entire lot up. And then we changed grade to be measured from finished floor. It was kind of a knee-jerk reaction. The Board of Adjustment was seeing a lot of these cases come in because if you measure from the lowest adjacent grade, they were only able to get, having a 6'6" fence or wall, they could only get a couple of feet. And they didn't have any privacy in their backyard. There was a question about fall protection. The guard wasn't high enough. It needs to be at least 36 inches for residential. And so those were issues. And so after that communication, the City Commission did ask us to take a look at it. And we kind of had a quick reaction to it and came up with the code change that you all approved for it being at finished floor. So now at finished floor, what happens is and again, I'm going to use an extreme case because I've seen some of these walls up to 14 foot tall on the lower lot. And I've gone and visited many people who had issues with the way that we approved those walls because they're kind of looking at this huge wall that's on the top. So what ended up happening is they'd bring these lots up, and there's lots beside it that were still at the lower elevation because they weren't doing anything that triggered them to come up higher. And they would come to the Board of Adjustment, and we passed that. So now we've got somebody with a finished floor of 8. The neighbor has a finished floor of 3. And now they can measure from the 8 and go another 6 foot taller. So now they're at 14, about 12 foot higher than, like, say, the other one, 11, 12 foot taller. So the neighbor now is looking at this huge wall. And the majority of the zoning districts in the city of Fort Lauderdale have 5 foot setbacks. The vast majority have 5 foot setbacks. So as you're looking out your window or you're in the side of your house, you know, you have these towering walls that are beside there. And I've gone out, like I say, quite a few times to people, and I've had to explain to them that it does comply with the code. So we came in and we wrote, I think, an overly complicated request, but the one we have today is very, very simple. And it's very close to the original definition that I just wrote, that I just read to you, but it's missing that last part where it's measured at the base of the retaining wall. So what we're looking to do now is change the definition back to the accessory structure being measured from the base of the accessory structure on the site that's installing the fence or the accessory structure instead of the adjacent.
I have a question. So you just lost me on that. I was understanding where you were before, but if I'm a new build and I'm at elevation 8 and my neighbor is still at elevation 3,
Go ahead, I'm listening.
which side of the retaining wall? I'm now without a fence, I'm going to be at 5 feet higher than them.
Yep.
But on my side, my dog can fall off the ledge because I don't have a fence on my lot.
Dog, kids, everybody.
Kids, anybody. So where are we now measuring? Because
So-
I'm going to need at least a 3-foot fence. Otherwise, I'm out of code, right?
Yep, so let me show you a couple of things
Okay.
on the slides. So this would be more like what it was originally. And this represents a couple of lots that are similar. And if this person was putting in the wall, the height would be measured from the opposite side at the base of the retaining wall. Go to the next one, please. Now, this is the situation that caused the issue. So we've got somebody bringing in fill. They're having to measure the height of their total wall from over here. Now, if this is 4, 5, 6 feet, they're only able to put a 2 foot 6-inch wall up, which,
That doesn't work.
again, somebody
That
can
doesn't work.
fall over. So what we did is we changed it to the finished floor elevation. So now they were able to install their 6 foot or 6 foot 6 fence or wall. But what it created was a really high wall on the neighboring property. And like I say, a lot of people they've called in a lot of complaints and everything. So what we're trying to, and these are just some pictures that I took. That's the retaining wall. And you can see how this retaining wall is almost to the eave of the garage. That's how high it is. And then they could have put another 6 foot 6 wall on top of that. So it would have been a 12.5, 13 foot wall that the neighbors would have to look at. And again, that's the neighbor's complaint. And then this one is one of the more drastic ones. Their finished floor is like at 8.6 or 9. And luckily, that neighbor didn't go as high as he could have, because the top of that retaining wall is right there at his finished floor. If you come across, he could put another 6 foot wall on top of that. And I went out and talked to this guy, and he wasn't real happy. But the other issue, especially in his case, that this creates is on the waterway side of the property. We have that code section in the fence section that says the last 10 feet to the property line can be no higher than 30 inches unless it's 75% non-opaque, see-through. That way it doesn't obstruct waterway views for the neighbors. Well, in this case, the guy had like over a 6-foot solid wall all the way to the rear property line. And when I was standing on his property in the back, I could not see down the waterway at all. So that's another issue that comes up. So go ahead and go to the next slide, please. So in, I think it was October of last year, the flood ordinance was updated to include no fill. Fill is prohibited except for minor grading for drainage. So now that's created another issue in that now if we've got buildings built on stem walls, we're grading down so it meets the grade on the other side because you can't have any fill. We can still fill in here, but the fill's here. Now we still have walls that are being measured from the slab, finished floor. So now you got a huge wall on both sides, but that meets the current code. Go ahead and go to the next one.
So do you fall out of your
Oh, that is the last one. So. I'm gonna
Because
use this one.
if you don't fill,
No.
then now I'm falling out of my
Well,
yard
if you've got a
house.
side door, yeah, I mean, what Brian brings up, but it's an accessory building, or it could be your permanent building. So,
But you'd have to climb up and down steps to get into your house, just like they
you'd
do
have
up
to put
north.
your air conditioners up on your second floor.
Or it's up this high on an elevated slab. But anyway, what this does is now with the code change, what we're doing is just requiring any fence to be measured on the side that the people are building it on. So it protects somebody who has already gotten an elevated lot. In the future, they won't be prohibited from putting a 6'6" fence up there because the new code will allow them to put it up because it's measured from their lot. Whoever's installing it, that's the side it's measured on. But then it also protects the neighbor from having 12 and 13-foot walls.
But then what happens when the neighbor, who now is going to take their multi-million-dollar lot and sell, and the next house next door has to raise their foundation up 5 feet? So now we're creating a river between the two where they're both
Which
dropping
is-
down 5 feet?
Yeah, which is exactly what FEMA wants. So the other point I'm going to make is that we have a thing called the Community Rating Service System, CRS, and that rates each city with a number from 1 to 10, 1 being the best, 10 being you're kicked out of the NFIP, the National Flood Insurance Program. And by letting someone put fill in their entire property,
We all good.
it reduces the score that we can get, our rating. So we're currently a 7. We used to be a 6, but our last audit about 4 years ago, we got bumped 1 up, a little bit worse than we were before. And with each one of those points, everybody who has flood insurance in the city of Fort Lauderdale gets a 5% discount on their flood insurance premium. So every time that thing bumps up, the entire city loses a 5% discount.
Can I
which
ask
is
a question?
Sure.
I haven't seen that situation in my neighborhood. They're still going out to the side. Are you telling me that the law has changed now and they can't go out to the side anymore?
That's correct.
They have to leave that 5-foot side yard at the existing grade?
The code also does allow for the city
didn't know that.
engineer. The code does allow for the city engineer on a case-by-case basis to bring it up more than what the code actually says. It's at their discretion. I mean, there's probably quite a few different reasons why that might happen. But again, we're trying to keep that down. And that also was caused by a lot of neighbors who were complaining that they were being flooded out
Yeah.
because of all of the islands that were up. And so the city commission directed DSD to form a committee And this is what we came up with because
So about the community rating system, are you, is it true that by changing our ordinance to prevent the fill all the way out to the lot line, it improved our rating?
that's correct.
It improved our rating?
And,
Okay.
and actually, we're still allowing them to fill inside the stem wall.
Well, that's, yeah,
To reduce.
Best practices for FEMA is to leave it empty
yeah, so water rushes.
and then put in flood vents so the water just flows
Rushes
in and
through.
out.
Yeah,
That's
yeah.
best practice, and that's when you get 100% of the credit for that.
Got it, okay.
Then the mold sets in.
Yeah.
Yeah,
With
no,
the
you
new
don't want
FEMA policy, isn't that gonna alleviate a lot of the tall fencing because you're not doing any more retaining walls?
Well, it won't because
It's still going to be.
it's still measured from finished floor, no matter what.
Oh, well, we gotta change that part. I see
Right,
what
so
you're
that's
saying,
all
yeah.
we're changing is
Right,
that
right.
it's,
Okay.
if it's an existing
I see.
height,
Because
we're not
of the
gonna
stem.
penalize them and we're gonna let them measure it from their side of that height.
Yeah, the grade's not changing now,
Right,
so
but
they're
on
both
the
gonna have
new
the
one,
same grade.
it's gonna be, it's down here and it kind of alleviates both issues.
So they don't have to do a shadow study anymore when they're building something.
No, not at all.
But
Not at
all the new construction that has happened in my neighborhood is already, put in retaining walls. As I was under the impression that we have to put in a retaining wall for the new, which is adjacent to us, to Birch State Park, the new fire station. Is that now not going to be required? Because I understand that's why we were so far behind on that, is that we have to create almost an angled circular drive so that we don't bottom out when we go with a truck onto Sunrise, because the elevation, they were requiring us to put that station.
I don't really have an answer for that. I'm not I don't have any knowledge.
But what do we
about
do
that.
with all the properties that have already put up retaining walls and have filled in?
Then
So-
they can install a fence and the measurement is done on their side. Can you go back one slide, please?
So
And the neighbors get screwed.
The measurement will be taken from their
Life is-
side. So if this guy's installing the fence, the measurement's over here as opposed to when it was pre-21, it was way down here.
Yeah.
Can you restrict that to, what's the minimum fall height, 42?
30 inches for
30.
residential, 30 inches. And then you have to have a minimum 36-inch guard for residential.
So couldn't you make the minimum 36 inch, which provides for fall protection?
Well, part of the complaint when people are going for a variance was that they're in their backyard, they're having a barbecue, they're in their pool, they're walking around, they're really not afforded any privacy because they're standing up above that 3-foot fence and they want a 6-foot fence, so they're afforded the same privacy as anybody else, and that was one of the biggest complaints.
So what are we actually changing?
Where
Because
they
we're
measure-
still,
Where they measure the
measured
base
from.
okay.
So go,
But isn't that where they were in this?
Create a moat and measure from the bottom of the
so this is the new code.
How's the water gonna get out? Wow, that's a very good point. If you follow that down to the water, now the seawall is as high or higher than that grade.
Well, you have to understand that tidal barriers, that code changed a few years back as
I know
well.
that, yeah.
And the maximum height of a seawall throughout the city is 6 feet right now.
I know, so I'm looking when I'm walking down that alley, which is really just an alley, I'm looking at potentially a 5-foot high seawall. And how's the water gonna get out of there?
Well, it's not really meant to flow over the seawall in the first place. It's meant, properties
I
are
know, but when it
required.
rains, the water floods, the water's gonna go down there.
I understand, but in most cases, it doesn't exceed the 1-inch criteria for stormwater calculations.
No.
It gets, in most cases, but when
Don't
we
go
have
there.
a
Don't
big
go there.
event,
No.
then it does sheet flow.
It does. Okay, I see the problem.
Okay.
Does this have, are freestanding shade structures impacted at all by this?
They'll be measured from the same ground level as the fences will, so it shouldn't impact them at all.
Okay, thanks.
Related to Eddie Ford's.
I wish, I wouldn't be here talking to
Henry.
you today.
We good?
All right,
All right. So we'll
thank you.
see this.
Thank
in
you for the
summer.
explanation.
Thank you.
With that being said, meeting adjourned.
All right.